Hi, today I'll be talking about common law and civil law. So this will be uh, very brief. So normally you get about a normal lecture will be 3 hours, yeah, but I'm doing it in maybe less than 30 minutes. So these are the picture like you can see the law reports, and traditionally before the availability of internet search engines, a lawyer has to have a collection of all these reports. So there will be maybe 50 or 100 of these books in one collection. Okay, or maybe more lah. Sometimes you got 200 books, 300 books. So you have a room full of books. So now you have a search engines. You got all the online reports. So make it easier for you to search cases and all. Okay, but I never personally experienced reading all these things before. Summary. So we have I'll talk about the background of both, then what are the history and the issues, and the history and issues of both, and then what are the different procedures, and conclude. So, common law we came from UK, and then UK of course went to UK, US, Hong Kong, Singapore, Malaysia, Canada, New Zealand, Australia. So all the UK, they call it countries, are big common law system. So most of the world actually is following a civil law system. Okay, most of Europe, most of Latin America, South Korea, Japan, China, Indonesia, and most of Africa. So how it came about is because of the revolution. Civil law is because the judges were the bad people. Judges collect, they pay for the position to get into a judge, and then when they die, they sell off their position to another person, so it can be inherited. Also, they hate the judges when they revolt, and so they say now judges cannot have so much power. It has to be parliament, right? When they kill the king, they kill the king, and then they say, the judges have no more power lah. So whereas in common law, the judges were the good people. When they overthrow the king, judges were actually helping the revolution, and they didn't they were not part of the king lah. I mean what lah. So that's why the common law judges still have a lot of power, had a lot of power all this while. So the common law system started from about this year lah. It can be traced back to this year, whereas civil is before Christ. Is and then from the Roman time, it starts from Roman law, so it's much older. So we have a history of common. So yeah. So initially, the judges will go to the villages, and then they will ride a horse, and then they will take down notes right, and then they will share their notes. So you develop after the judges, when they share their notes, they develop a system. So the system after 200 years it became fixed. Okay, so you had a common law is based on precedent, what the judges decided, and then they decide to fix it. But then the problem when you fix it is new actions cannot be created. So they came to the king. They say, King, please give us justice. The lawyers, the judges cannot give us justice. So the king will hear their case. And then later the king said, there's too many. I don't have time. So he give to the chancellor. The Lord Chancellor was some used to be a person from the church, okay, the Roman Catholic Church, and he will judge based on equity lah. Equity is fairness or justice, right? So later on, it was merged into the same system. Parliament merged it into the same court system. That's why now you go to court, you got equity and you got common law, they say. But actually, both of it is what lah. So later, but now equity also became, they got a lot of fixed rules already. So it's supposed to be fair and just, but become now fixed. But actually, the law has to keep developing because, for example, if we follow the law from 1600s, women cannot own property, cannot study, cannot vote. Only about 100 years ago, then only they had voting rights and they can own property. So even 50 years, technology will be outdated. Last time there's no internet, no computers. So we cannot follow the law, so it has to keep developing. So even equity also we have to develop it. So but who is going to create the law for us, right? It depends on the boss lah. Normally, of course, we can suggest to the boss, right? But the boss is who are. So we have and mental element is very hard to determine. Like when we talk about negligence, recklessness, intention, who knows what the person is thinking? He purposely do it or accidentally do it. You only God can give you pure justice, because God sees everybody every time, all the time. Uh, right. So even you want to prove something, did he kill the person or not? You need to prove, but sometimes it's based on percentage. The judge say beyond reasonable doubt or balance of probabilities, more than 50% he killed the person, more than 90%. You don't know 100%, right? So you won't get. It's not a perfect system, and if we let the politicians create the law for us, also we have problems. Okay, because we know politicians are not there to serve us; they are there to serve themselves only. Okay, so we have issues in common law. Yep. So these are we have the interpretation issue. So like for example, I say please do good. Please don't be a bad person. Be a good person. Then I ask you, what is the meaning of good? What is the meaning of bad? Because good and bad is just a word. Okay. To somebody, good is something else. Another person will have something else. So words need to be interpreted. Okay. But how do we interpret? So we have the literal meaning. We say you follow the dictionary lah. But sometimes the dictionary meaning says nothing, like please don't drive a motor vehicle in the park. What is a motor vehicle? Is a bicycle a motor vehicle? If I put a motor on the bicycle, is it a motor vehicle? You don't know. Then we have to look at the mischief rule. Mischief rule says what the legislation is trying, what is the problem that the legislation is trying to solve. And then we got the golden rule. Golden rule is almost like purposive rule. Is what is the purpose of parliament when they create the law legislation. Right? So sometimes the judges will say we follow literal. If literal don't make sense, then we go to mischief. If mischief still don't give us a good result, then we go to golden and purposive. Yeah. So some people straight away they go to purposive approach. So different depends on the judge. Okay. Different country will be different. So we got case reporting. So case reporting is because common law is based on precedent, what the previous judges decided. We cannot change. We have to keep following what the previous judges change. If we want to change, we have to go through special procedure to change the law, right? Because judges make law, their decisions become law. But how do we know what is their decisions? What cases come out in the reports? But you know that there are thousands, maybe hundreds of thousands of cases. So nowadays only new points of law, all the same point of law they won't report. But who decides all this is based on the law reporters, right? The law journals, and there are not many, maybe a few only. And sometimes parties decide to settle themselves. All this won't go to court, so it won't get reported. And only higher court like appeal court and Supreme Court or federal court will be reported, right? Normally high court seldom get reported also. So you don't know all the lower courts, you don't know a lot of cases. And we got following precedent, so we can distinguish, right? We can decide to follow or not to follow the case also. Sometimes we say you got different facts, so I want to distinguish. I can overrule the law. So if the previous law is wrong, I can overrule it also. So this one depends on the judges. So different parties will try to convince the judge. One party will say you must follow this previous law. The other party will say you must follow another law, another case. And then they say because the other case is wrong or the facts are different. So how you want to decide how you want to convince the judge. Then we got judicial appointments also for judges. So because judges cannot be politicians, so they have to be elected appointed based on ability. So ability, how do you determine who will make a good judge? So they have this thing called merit. Merit means the most deserving. Okay, but of course you look at we know in some countries it's not merit, right? Sometimes if the politician like you, the prime minister like you, then you become a judge. Or or let's say we don't know for sure, but that's why they got an independent commission in UK, and then Malaysia lately followed to decide who becomes judges, they have a committee to decide. And we have independence. So judges cannot be biased towards one party. Of course, they, let's say they got an interest. Let's say, like, Lingam Singh, he went to New Zealand with the judge, and the judge was judging his case. So of course the judge is going to side with him, right? And many cases he was very close to the judges. So a lot of lawyers say every time I go to court with this Lingam, BK Lingam, I sure lose one, because yeah, and then there were allegations that he helped to write the judgments, and then he give the, all these things. So all this, there's apparent and actual independence. So even though you are independent, you must appear to everybody that you are independent also. So you cannot go yamcha with the lawyers, for example, yeah. And we got lay justices. In UK, lawyers can become part-time judges also. So 1 or 2 days a week or something, you go and become a judge to clear the backlog lah. And also it gives the lawyers experience. Malaysia, they suggested, but I don't think they implemented it lah. Right? But this lay justice is very good because some lawyers, they are very good lawyers, but to become a judge, your salary will go down a lot. Okay, so at least it helps you to contribute back lah to the society. And then we got legal fees. So legal fee is very expensive for common law. They got legal aid, but legal aid now only about 10% of people in UK are eligible only. Very little lah. I forgot how many, but Malaysia is even lesser. Okay, maybe 1% or something, or 5%. So you legal aid, so the government will pay your legal fees, but of course we know that no such thing anymore lah. Okay, the parliament will always say they got no more money, budget cuts. And then we got contingency. So the lawyer will say, I fight for you for free, but if you win, you give me 30% or 20% of your winnings. Right? So this one, it can be a lot. Okay, like let's say, especially for negligence cases, for personal injury cases, right? Especially, let's say car bang you, let's say they will say, never mind, now you're injured, I will fight for you for free because you got no money to pay my fee. I'll fight for you for free, but you give me 20-30%. So a lot of people start suing everybody. Every time you got accident, the lawyer, never mind, I fight for you for free. But you win, you pay me. So people start suing. Every time any accident, people start suing. So it's not very good. All these things, and of course it can be good, it can be no good lah. Like there's this case, if or you get cancer because of an accident, in a workplace, then of course it helps lah, because you want to sue the big company, you got no money. So decisions to prosecute. So normally the public prosecutor in a criminal case will base on evidence, public interest and policy to decide. Of course the victim will say, you must prosecute him, but too bad the victim cannot decide whether to prosecute or not. Only the public prosecutor will decide based on all these three things. Alright. Yeah. So it's a history of civil law. So civil law started from the Roman Emperor Justinian. Of course, actually it started before that also lah, but Justinian was the one who decided to codify everything, because there were too many law scholars. Law scholars were the one who write down the law in the books. But everybody have their own opinion on what the law is. So people confused. People say, hey, maybe it's this, maybe it's that. And then no more. I will compile everything, but I'll only look at the top scholars, and nobody can write any more commentaries. No more books on law. Even a book about my book also cannot. But he faced a problem because there are a lot of situations, but he tried. So he came out, but of course people still write books about his book. But yeah, people just ignore his law. Of course, if you got stupid law like that, then yeah. So and the later on the history of civil law, because the emperor became Christian eventually, the Roman emperor. So it was influenced by the bishops or the pope or what right? So they say that civil law is the top contribution in Western civilization. So or is it language? The English language also come from Rome, but they say this is the law because now the civil law is everywhere in the whole world, right? So without this law, so which is higher, is it language or law? Right? We don't know now, but we live in what lah? For of course, then universities. They went to universities to study, so they will study civil law and canon law. Canon law is like the church law. So lawyers will be trained normally in both. That's how civil law develop. Uh, so completeness. So you got issues like you need to codify every situation. So if, for example, in France, right, they cannot because when Napoleon write his code, there were very little tort cases. So he didn't have much to say about tort. Tort means basically most of it is like negligence. So if you get into an accident, the accident who is negligent, or negligent is carelessness. So um so most of it, like for example in France, is still based on judges' decisions. So it's very hard to codify everything. You got problem with interpretation also. So but they send the interpretation to a committee, parliamentary committee. But now the trend is slowly moving. They are slowly saying judges have the power to interpret. Okay. Because civil law, they are very separation of powers. They say judges can never interpret, judges can never make law. See, so the power judges is just like a machine operator. To them, right, the judges are very lowly paid. They are like your very very low person. You just do what the parliament says. Uh, Whereas UK, they are called lords. They are called chief justice, or lord justice, or lords, or sir. All of them got very heavy title, and they are very influential because why their decisions become law. So which is better, we will conclude later. So judicial appointments, we got they go to school. In civil, they go to school, and then once you go to a judicial school, you will become a judge already. You cannot become a lawyer, you cannot become a public prosecutor anymore, right? So you cannot jump, you cannot have a different experience. Whereas civil law, common law, you can become a lawyer, then you can become a judge, then you can become a public prosecutor. So this is some issues that good or bad okay. um, and in order to develop the law, you need to the facts have to suit the law. Okay. For common law, uh, the law suits the facts. For civil law, the facts will suit the law. You have to, because the law don't cover your facts, so you have to try to modify your facts to link it with the law, right? Whereas common law, you try to make the law suitable to your facts, right? And civil law, you got no equity, so you got no things called justice or fairness, right? You don't have such a concept. And civil law is very based on legal science. Legal science means law is science, so there is a something called absolute truth. So every time you want to come up with a law, you have to look for a principle. You're not trying to solve any problem. Whereas common law, if you're trying to solve a problem, then you come up with the law. Okay. So all this is work done by scholars, right? The politicians were based on the scholars, so they don't consider like economic consideration, insurance, all those don't. And so the question is law science or not? I used to think law is science before I started studying. I used to, because I'm from science background, so I think law is science, right? Mathematical, is if your facts is like that, then guilty means guilty, innocent means innocent, yeah. But the more you study, then yeah, but the whole most of the world believes is like this lah. So politicians, you see, they never study law, right? So they got a lot of power, but they never study law. They never read. Lawyers who have read 100, 200, legal cases. They will have read hundreds of legal cases. They know, judges and all. They every day they look at cases, ma. But politicians, what do how familiar are they with law, right? So I don't know because I never live in Germany or France or Spain, right? So I don't know what is the perception now of their capabilities. Okay, so we got procedures. For example, the civil law, the lawyers will give the witnesses and the judges their questions, and then the judge will modify it and he will ask in his own words. So actually it's the judge asking the witnesses. Okay, lawyers don't direct talk to the witness one, all go through the judge. So, and no surprises, everybody know what is the question going to be asked. Whereas common, you don't know what question, you are the witness, you go there, people tembak you with question, you die on the spot. But and there's no cross examination in civil law. Okay, for example, if the person is not credible or what, you won't be able to convince anybody, right? Whereas civil law, you can cross examine. You can, one guy give a witness, then the other party can cross examine the witness to see whether is it, what is he telling, is it true or not. And then we got dissenting judgment. Civil, we anonymous, so you don't know what the judges decided, and it's unanimous. Even though 2 out of 3 judges disagree, everybody will come out with just one judgment, and it's not very long one. It's very right. Whereas common law, let's say 3 versus 4, you know what the 3 judges are thinking. Even though if everybody say agree, but they have their different reasons, in common law you will see all most of the time you will see their reasonings. So which is better, so damages, civil law, they don't believe in civil cases to penalize you. You want to penalize, you must go to criminal law already. Whereas civil law, if you are grossly negligent, then they will raise the damages right? Let's say you hit somebody's car, under normal normal damages, you have to just pay for the repair of the car. But if you purposely, really grossly negligent, then you have to pay more. Under common law, you can sue for it more. So conclusion, which is better? So we have, in civil law, the judge is a player. Okay, he's the one questioning, he's the one finding out the truth. They call it. Whereas common law, the lawyer, you got lousy lawyer, then too bad. So you have to pay a lot for legal fees. The guy who can afford the best lawyer will normally have an advantage. Whereas civil law, legal fees are very cheap only, right? And civil law, you cannot no plea bargaining, right? You cannot, let's say I plead guilty and then you give me a lower sentence. I save the court time, I save money. But civil, they don't believe in this. Common, common God, and then common is judges can change the law because judges decide the law. So today is one, next day is one. Whereas if you go to parliament, parliament will take a vote, and then you have to table a bill. It takes years to come out a law, maybe at least months. Okay, and then common, you see common has, so in conclusion, we see common has very good substantive law, right? Because it developed over hundreds of years, right? Maybe thousands of years it has developed. Okay, so it's quite good But in practice, because the judge is just a referee, just sit back and then he let the parties fight. So because of that, in practice, sometimes you don't get justice. Okay, a lot of times. Civil, the substantive law, my opinion is not as good. Because you don't have it's not based on problem. You're not trying to solve a problem. You're just trying to find absolute truth. But it's more practical because the judge is a player of it. Okay. Yeah. Okay. Thanks.